Bring the committee meeting of the House Elections Committee to order. Our first order of business is approval of the minutes. The committee assistant should have sent out some minutes for February 7th and for February 9th. I hope everybody's had a chance to look at those. Do I have a motion, Representative Neighbor?
Thank you, Mr. Chair. I move approval of the minutes for February the 7th and February the 9th as written.
I have a second from Representative Underhill. Is there any discussion? Hearing none, all in favor of approving the minutes, please signify by saying aye. Aye. All opposed, nay. The ayes have it. The minutes are approved. Okay, our second order of business is a hearing on House Bill 2391. So I'll open that hearing and ask Mr. Jason Long, our advisor, to tell us about it.
Thank you, Mr. Chairman, members of the committee. House Bill 2391 makes several amendments to the Campaign Finance Act. These amendments affect the powers and duties of the Governmental Ethics Commission, the qualifications of its members, and also make several amendments regarding registration of political committees, and the investigatory powers of the commission. I'm going to go through and try and hit the highlights of the bill. Obviously, if you have any questions for myself or the proponents to clarify things that I don't quite touch on. To start with, there is a new statute proposed under House Bill 2391 to be a part of the Campaign Finance Act. This new provision on page 1 of the bill would make the actions of the Governmental Ethics Commission and its staff subject to the Kansas Administrative Procedure Act, the Code of Civil Procedure, the Judicial Review Act, and the Public Speech Protection Act. And so any conduct by the commission or its employees could be questioned, challenged, brought for review under those various statutory schemes. There's also a new provision that requires commission to bring any action within 2 years of the act first giving rise to the cause of action or complaint with the commission. Also, there is a provision that limits the liability of individuals who are held liable for on behalf of another person or entity. They would have to be acting as an agent, and there is a new definition of agent added to the Campaign Finance Act under House Bill 2391. So you would have to meet that definition in order to be held liable, responsible for any action on behalf of another. There are some adjustments to qualifications. One, the executive director under the bill would have to have the same qualifications as the commission members. There's also an amendment on page 3 of the bill that removes the prohibition on commission members being former office holders. So that prohibition would be removed from the statute. Getting into some of those definitions, you can see those beginning on page 4 at the bottom with the definition of an agent. There's also a change in the definition on page 7 of a political committee to add a monetary qualifier in terms of the entity to be defined as a political committee. There's also further more clarifying terms on page 8 to clarify that definition of what is a political committee for purposes of the Campaign Finance Act. There are amendments on page 10 regarding registration of a political committee to create an intermediary level of registration for those that are established and are anticipating receipt of between $2,500 and $10,000. They would have a lower registration fee of $100. If you get more than $10,000, it's the current statutory amount of $300. There are a couple of amendments throughout the bill to redirect any fines that are collected by the commission so that they would go to the state general fund rather than the Governmental Ethics Commission fee fund. The bill does amend statute 25-4153A, which governs what campaign contributions can be expended for, to expand that list. Let's see, I think I lost my place here in just a minute. Hold on, I gave you the wrong site on that. It's actually 25-4157A, I believe. Yeah, is the list of what campaign contributions can be expended for. Page 17 of the bill. New expenditure allowances would be expenses and compensation and gifts for volunteer, staff member, or contractor of the candidate's campaign, provided to any volunteer staff of the candidate's political office, payment of any civil penalty imposed by the commission, payment of legal fees related to any matter brought under the Campaign Finance Act, and finally, payment of expenses incurred for family caregiving services that are directly related or have an effect on the candidate's campaign activities or duties as an office holder. So those would all be new expenditure allowances for campaign contribution funds. In terms of investigation, the bill makes some amendments. It would require that in order to issue a subpoena, the commission would first have to have a verified complaint before the commission and a finding that probable cause exists pursuant to 25-4161E. The commission can request that the attorney general or the local prosecutor file an application for an inquisition in a district court for investigating potential violations of the Campaign Finance Act. It does provide a conflict provision under the bill that no attorney or staff member representing a complainant before the commission can engage in any ex parte communications or otherwise advise, represent, or assist the commission in any matter before the commission. It does provide any respondent to a complaint the opportunity to have, prior to a hearing conducted by the commission, to request that the hearing be removed and be held before a presiding officer from the Office of Administrative Hearings, so they can move it over to that division. And finally, there are some amendments regarding the fines imposed by the commission. First amendment is that the fine imposed by the commission in any one matter cannot exceed an amount that is double the applicable fine for a single violation. The commission is prohibited from reducing, waiving, or otherwise modifying any fine that had been previously imposed by any consent decree or final order. Commission cannot order any community service or other specific performance in lieu of a civil fine. And then finally, the bill amends that statute so that the commission cannot enter into any agreement with the person that legally binds the commission from enforcing any law against that person in exchange for their cooperation with or assistance to the commission in any manner. So that's roughly, Mr. Chairman, the highlights. I'm happy to answer any questions. The bill does go into effect on July 1st, I believe, Mr. Chairman. Let me see the last page. Yes, July 1st of this year.
Could you also talk about the balloon amendment that that was sent out for this bill? Just what it changes in the base law or the base?
Mr. Chairman, I am going to apologize. I am pitch hitting for Mike today, and I have not had a chance to look at that balloon.
I'll ask one of the proponents to talk about it. But okay, are there any questions for the reviser? Representative Miller.
Thank you, Mr. Chairman. I note there's no fiscal note online. Are we to expect a fiscal note? I'm online.
If you look at the testimony for today, the fiscal notes there.
Well, I'm on the bill. Could you just tell me what the fiscal note is then?
I have to look it up again. Does anybody have it open? Go ahead. Mr. Vice Chairman.
The fiscal note, the Government Ethics Commission estimates additional expenditures of $200,659 from the general fund, state general fund, along with additional 3.0 FTE positions. Oh,
Follow up on that, the office.
Representative Neighbor.
I'm sorry, Mr. Chairman, I should have waited for your attention.
It's okay. Please, go
The
ahead.
Office of the Attorney General estimates an additional expenditure of $91,914 from the State General Fund, along with an additional .25 attorney FTEs and a .50 investigative FTE position in 2024. Of that amount, $72,405 would be salaries and wages, and $19,507 would be operating expenditures tacked on to the other.
Thank you.
If I may
Representative
follow-
Miller.
If I may follow up, I don't see anybody from the Attorney General's office, but I'm confused by that fiscal note in that House Bill 2289, and correct me if I'm wrong, Jason, but it appears that 2289, the entire contents of that bill mirrors your brief number 9 relative to subpoena power. And that one provision alone, according to the fiscal note delivered on February 10th, the Attorney General says that would be $162,000 just for that one provision. And yet, looking at the fiscal note on this bill, he's now saying $91,900 for the whole bill, which has a number of other provisions. So that's a very, very confusing circumstance. If I may, one more question, Mr. Chairman. In trying to do my homework and checking back when this bill was introduced by the committee, I noticed that the request was made by Representative Wagner. Are we to assume that this is his product, or is this on behalf of
I
someone?
believe one of the first proponents going to speak to the origins of this bill, but the first proponent is the one who worked with the revisers to do this. So this is not Representative Wagner's bill. It's a committee
I was
bill.
hoping to give him full credit.
Yeah.
Can't do that.
Can't do that.
Doggone it. Thank you.
All right, thank you. Are there any other questions for the reviser? All right, Mr. Vice Chairman.
just a point of clarification. The contents of this bill, if passed, obviously it's not retroactive at all. It does not apply to any current investigation. It's only for future investigations, correct? I mean,
Correct. The language in the bill is prospective.
thank you.
Any other questions for the reviser? Okay, seeing none, thank you very much. Oh, wait, you almost made it. Representative Underhill.
Actually, thank you, Chair. This isn't for you, Jason. Did Dana send out a balloon amendment? Am I missing something?
Yesterday, she sent out a balloon amendment, and I think that the first proponent's going to talk to that. It's just clean up because there was an error in the original bill. Okay? Thank you, Mr. Long. All right, so some ground rules here because we've got a lot of conferees and we want to make sure that we give plenty of time for the committee to ask questions. I'm going to allow the first proponent 15 minutes, if you can keep it in that. And then the other proponents 5 minutes each. And then I'll also give the opponent 15 minutes because he's the only opponent and I'm sure he's got a lot to say. So with that, our first proponent is Mr. Josh Nye. Nay, sorry.
You got it right the first time, 9. May it please the committee. Thank you, Chairman Proctor, committee members. I'm happy to address the balloon amendment first, if that would be helpful. I don't know if that's going to count against my time, but got a lot to get through. The balloon amendment is really just, I don't want to blame reviser, but let me start actually here. In my testimony on page 2, under my conclusion that the Kansas Governmental Ethics Commission is structurally broken, I write, I have been directly involved in the drafting of HB 2391. Nearly every one of the provisions in this bill, is directly related to a significant due process issue or question of law that has arisen in one of my many cases before the Commission over the past several years, and especially over the past year. That's what I hope to get through today, but specifically with respect to the balloon amendment, when I was at least working on provisions that would address some of these issues that I'll talk about in a second. Some of the things were left out because of the timing of the session. The first thing is that there was an incorrect reference to the Governmental Ethics Act in the first page. It would substitute campaign finance. It's just a technical amendment, a drafting error. Second is that the provision that provides that not more than 5 members of the commission shall be members of the same political party and should not have been struck out. That was not the intent of the bill. So that the Balloon Amendment would restore that. The other balloon amendments are amendments on page 6. The definition of coordination that had been drafted was left out completely of the definitional section, even though it had been sent to the revisor as back and forth drafts, that type of deal. This is a coordination standard that is adopting the federal standard for coordination. Right now in Kansas, we have a cooperation and consent standard, which is distinct and not as well defined as the federal standard that has plenty of FEC opinions and case law, including safe harbors and conduct standards. So that's where you get those. I think there are some proponents today that are far more expert, including a former chairman of the FEC that's going to be testifying today, that far more of an expert than I am on that, but that's what that is. And then the political committee definition had a few drafting errors. That's mainly the same definition that was in the original bill. The main issue is that we've changed what is a major purpose test that many of you may have read about in the news over the summer. That was the significant legal issue in my Fresh Vision OP case that was pending before the commission. Major purpose test that currently exists in regulation adopted by the Kansas Governmental Ethics Commission. This would pull that into statute and have the legislature actually articulate what that is. And we believe this is at least a starting point for how you define not only what is a political committee, but set some bright line rules, because the current major purpose test, I think that you'll hear today, is considered patently unconstitutional. And if the legislature doesn't fix it, I anticipate there will be federal legislation or federal litigation in the future to have that defined. So something has to happen. Political committee. And finally, the provisions of the 2289, I think Representative Minority Member 23, that had the original standalone subpoena provisions that would transfer that into a judicial inquisition process. That had more language specifically from the revisor that he recommended, and so just pulled that language into this bill, which was not as long. And then finally, the trial de novo provision would actually clarify more language. Instead of just saying an appeal to the district court shall be a trial de novo, it would say, notwithstanding any other provision of this act, the trial de novo shall include an evidentiary hearing at which issues of law and fact shall be determined anew. That language is copied verbatim from, I think, 74, 24, 29, or I'm doing that from memory. It's in my testimony. The BOTA statutes and then several other statutes that allow certain types of proceedings that administrative hearing officers and bodies oversee and conduct an evidentiary hearing. When you go to district court, it's a start over basically for findings of facts and conclusions of law. So all that to say that with the balloon amendment, that was the starting point. And that starting point really comes out of my standing here before you today as a practitioner. I'm a legal practitioner. I represent your constituents in the courts. I represent your constituents in front of administrative agencies, and for the past 14 years, I've not only represented many people in front of the Kansas Governmental Ethics Commission, but I've also litigated a week-long federal jury trial based on Kansas Campaign Finance Act-related wire fraud and money laundering allegations. And so I think I'm at least have some semblance of experience to be able to address how this works in practice. And because now is the time to begin the conversation, the legislature, if the legislature doesn't weigh in, it's people like me and your constituents who are my clients that are in the wasteland, so to speak, or the no man's land of litigating in front of the Kansas Governmental Ethics for the 7 months after you adjourn sine die. And last session, the whole issue of the Fresh Vision OP case was fresh in everyone's mind, I think, in April and May of last year when these things started to come to light surrounding qualifications for the executive director. I frankly think that that is a distraction from the core issues that were just starting at that point in the Fresh Vision case that I hope to go over today. Because this is really where I hope the legislature will start to discuss in a bipartisan manner what the law should be. And when I say what the law should be for future generations, when I retire, when you retire, what should the law look like? What should the law look like if Executive Director Mark Skoglund and I had to switch sides every single hearing? What should it look like for fair due process if the shoe is on the other foot? What should it look like if the standards that are being applied to one set of your constituents aren't necessarily applied to another, but all those questions as far as procedural fairness as well as substantive clarity are before you, the legislature. There's no question that the current executive director of the Kansas Governmental Ethics Commission is an activist. There's no question. You can read that in his comments in the newspaper. You can read that in his legislative proposals. You can read that in his Twitter feed. You can see he wants the Campaign Finance Act to look a certain way and to restrict certain types of activities. He has a substantive opinion about the law. And frankly, I don't think that's wrong. I don't think it's wrong for a prosecutor and for an executive branch agent that is in the business of accusing to have an opinion on what the law should be. You hear from my colleagues as county and district attorneys all the time up here who are charged with enforcing the laws as you've written them. The question I have really is who oversees the activist? Who holds the activist accountable? And ultimately, what we've seen over the past year is that there's big questions of if anyone does. Does the legislature hold him accountable? In January 23rd interview, Mark Skoglund said the following to the Capitol Journal. In an interview, Mark Skoglund, director of the KGEC, said any legislative move to overhaul the agency would have major consequences. Any attempt to undermine the Ethics Commission should and will be viewed by Kansans as a direct shot to their ability to trust governmental decision-making, he said, as well as ethics and transparency in the state of Kansas. So me showing up at this very hearing and us discussing this today, that's a direct shot at ethics and transparency. If it feels like you're being gaslit by that comment, as duly elected legislators, you are. This comment is the bureaucratic equivalent of your kid threatening to scream, "You're not my mommy," in a public marketplace if you make him stop climbing on the display racks. It's being held hostage. You're not allowed to question an administrative agency with ethics in its name, or you're unethical. And so finally, after years of practice in front of this commission, years of practice of dealing with federal prosecutors leading to an acquittal at federal trial, I'm tired of being gaslit. I'm tired of being run through a kangaroo court. And that ultimately is the case I have for you today. Every one of these provisions, like I said, I've listed, and I prepared this spreadsheet. Sorry for the size of the text. Every single one of them comes out of some sort of error or due process violation or substantive abuse of broad and ambiguous language that you need to clarify. Every one of them. The application of general civil and administrative procedure laws. In the Fresh Vision case, which I'll get to as I go, because I know I don't have a ton of time. In the Fresh Vision case, I watched the March 23rd hearing that my clients behind me participated in a pro se capacity. I was not their lawyer at that time. I was monitoring it by Zoom at the time for other matters. And I watched, and this was the biggest travesty of due process I think I've ever seen in terms of pro se litigants getting the runaround by a hearing officer that's not used to giving hearings, but is used to having people roll over. And he thought that because they were not represented, they'll continue to get what they want. And so the commission. So on March 23rd, I watched this hearing, and that's when all the attorney stuff came out. The issue was never about the qualification and whether the executive director should be an attorney. Of course, Carol Williams wasn't an attorney for 40 years. The issue in that case always had to do with the material prejudice that omission in that case posed to my clients as pro se litigants. So as soon as I was retained, within a couple weeks afterwards, you'll hear more from my clients behind me. As soon as I was retained, I filed a motion to dismiss, bringing up the fact that, omitting the fact that you're not an attorney, that you're a suspended attorney, and the basis on which you are not sworn as a witness is that you're an attorney, you owe a duty of candor to the tribunal, and so we're not going to swear you in, but these two, we're going to make you testify under perjury, the penalty of perjury. So I filed a motion to dismiss, and the commission at the April, everything blows up in the press, of course, and the commission at the April hearing has to hear from me for the first time. They deny my motion to dismiss, don't make any comment about the propriety of what actually happened in March 23rd, but I made the point that you don't even have a case in chief because there's no sworn evidence whatsoever. You didn't even swear in your only witness on the basis that he was an attorney, which is, again, even if he was an attorney, is not a category in law. I don't get special privileges just because I'm an attorney to not be sworn in. And so at that April 27th hearing, after ordering a rehearing, Commissioner Solbach says, Mr. Nye, I bring you back to the real issues here, and we found that your clients were a PAC. This is the point that they're supposedly going to hear it again in a neutral matter. Why? Because the majority of money that they raised was spent to support or oppose a particular candidate. All we're asking, and all the law asks, is that be disclosed. So this isn't dark money. It's a little late to influence the election, but that's the only issue here. And you're proposing something that I think is going to be very expensive for someone, not for us, but for someone, and it may end up with the same result. And I would urge you to counsel your client about the cost-benefit analysis of what you're trying to propose, and instead of simply accepting the fact that you're a PAC, doing the paperwork and being done with it. So at the very, very beginning, I get a shakedown. My clients get a shakedown. This is going to cost you a lot of money. You want to litigate this in front of us? And sure enough, they churned us and churned us and churned us. They made me file successive motions just to be able to depose the complainant in a case, just to be able to ask him about his investigation, just be able to depose the person who turned them in, their political adversary in Overland Park, just to get simple subpoenas. I didn't know the Kansas Governmental Ethics Commission found it very difficult to issue subpoenas. That was a surprise to me in April 27, 2022. But they sure had trouble doing it in June and July. By the time I'm pushing and pushing and pushing, and you can see May 25th, one of the commissioners confuses the idea of an allegation with a factual finding. She doesn't know the difference between what looks like something a complaint. Well, isn't that the truth? No, it's not the truth. That's the whole point of discovery. I get to raise a defense. We go through, I get warned on my 25th that I'm going to face potential civil liability if I issue subpoenas that are overbroad. I'm going to face civil liability for overbroad subpoenas. I didn't know the commission was concerned about issuing overbroad subpoenas, but apparently they were when the shoe's on the other foot. You can read my comments on August 24th. That's when we start, to his credit, Executive Director Skoglund and I, which we've worked together on cases and disagreed strongly on cases. And like I said, I don't have a problem with an adversarial system. I don't have a problem with him accusing and me defending. I don't have a problem with me, the shoe being on the other foot in Jefferson County. I do have a problem when there's no judge. When the judge is designed to support and rubber stamp anything the prosecutor wants to do. Especially when you have the ability to levy $5,000, $10,000, $15,000 for each count against unsuspecting Kansans for exercising the First Amendment rights. So at this point, to his credit, Executive Director Skoglund agrees that the major purpose test might be able to be improved. Maybe we can work together to improve that in the regulation. There's been tons of due process issues in this. Agrees to issue a letter of caution to my clients and start dismissing the case. Well, that's just the beginning. When the commission starts demanding that in exchange for them dismissing the case, the complainant had already asked them to dismiss the case with me, with prejudice, them dismissing the case, that they need a release, individual and official capacities, release for their civil liability, for attorney's fees, a release for me suing them for malicious prosecution. And that's in my testimony on page 8. You can't read it on this copy, and I can't get this to work. But you can see what they made us sign in order to dismiss this case. The judge was holding on to the case until the judge got immunity, until we waived those rights. Just unconscionable. And so as I go through this, and there are other issues where a clear conflict of interest.
Josh, can you wrap up here? Yeah. A couple more minutes. I'm giving you a couple more minutes because you had to do the balloon, but go ahead.
I will wrap up. The issue at the end of the day had to do with the unavoidable conflicts, and I very much encourage you to read every single word of these commissioners' comments during the OP case. But the unavoidable conflicts, at one point they were going to discuss the settlement and that we were going to do, and the civil release that they were demanding that we release them of individual liability. And they said, well, we need to talk to our agency attorney. Well, that's the attorney that's been litigating the case the entire time for the complainant, Mark Skoglund. And at that point, they just don't know what to do. And here's the final quote I'll read, and then I'll stand for questions at any point on any of these provisions. Mr. Solbach says, mistakenly believes that there's a trial de novo, which has gotten some press coverage recently, which I can talk about. He thinks that I get to appeal the district court trial de novo, and I don't. It's on an arbitrary and capricious standard. But I'll end with this. Commissioner Solbach says, after I object to the plaintiff's counsel also advising the commission in executive session without my presence as an ex parte communication, he says, we're an administrative body and there are conflicts and we just have to live with those. This isn't a court, and if someone doesn't like what has happened to them here in the commission, they have a right to appeal and have a trial de novo in a court where all those conflicts will go away. But we have those conflicts here and we have to live with them. We have to remember which hats we're wearing at various times and try to set those conflicts aside, but the conflicts are going to be there and there's no getting around them. He is counsel for the commission, and he's also a counsel for one of the parties. And you're counsel for their party in the hearing on the issues involved. If we ask staff to go with us into executive session, we just have to live with that. I would contend that that's an ex parte communication and formal hearing in violation of law and the rules and regs. Commissioner Solbach, I think that you're welcome to make that point, but that doesn't mean we shouldn't ignore it. I'm happy to answer any questions about the issues. This goes far beyond just the Fresh Vision case. Conflicts of interest. I would ask you to start the discussion, and I would contend the discussion belongs in this building and not in that administrative bureaucratic agency across the street. Thank you.
Thank you, Mr. Denai. Committee, I forgot to mention this. I'm going to wait until all the proponents have testified, and then we'll bring up the folks that you want to ask questions of. Our next proponent is on WebEx, Mr. Bradley Smith. Are you there, sir?
Yes, I'm here. How much time do I have, Mr. Chairman?
Try to keep it under 5 minutes, sir, if you can.
Okay. All right.
Go ahead, sir.
I'm a professor, so that's hard for me to do, but I'll try. So my name is Brad Smith, and I want to thank you for inviting me here. I'll note first, I'm not an expert on Kansas and what's been going on, what's happening on the ground. But as former chairman of the Federal Election Commission and a scholar and a representative, a practicing lawyer who's represented campaigns and others, I worked on the enforcement side. I think I can bring some thoughts on first principles and also simply what works and what doesn't work from the enforcement side of things. I want to note that at the outset, the Supreme Court has long recognized that limits on money spent in campaigns has the effect of also limiting political speech. If you limit it, how much the New York Times could spend to publish, nobody would say, oh, well, that's just limiting money. It's not limiting speech. And so the Supreme Court has always warned that we need to be cautious and careful in this area when regulating in this area. A survey by an organization that I founded after I left the Federal Election Commission called the Institute for Free Speech. We did a survey of all the state's laws just a little over a year ago. And Kansas scored a 65 in that, which actually wasn't bad, but could be quite a bit better. And HB 2391 would improve the state score. It would probably put it up among the top states in the country, the top 2 or 3 states in the country, in terms of the protection that it offers to citizens of the state, to Kansans who want to participate in politics, in political campaigns, and in the discussion of public interest or public issues. And I think that's an inherently good thing. There are a couple of especially good features about the bill. One is that it clarifies the definition of political committee. This has long been a problem, and especially when you have vague definitions, people who are out and gather around don't know what they have to do, when they have to report, what laws they have to file, because they don't know if they're a political committee or not. So you have a group that forms just to promote public issues or clean government or clean environment or whatever in an area, and they don't know when suddenly they're liable to be hauled before the Kansas Ethics Commission or in some other way be violating laws because there's not a clear definition. And this bill provides that kind of clear definition that I think will be very helpful, especially to these small grassroots groups that can't afford to hire a lawyer before they go out and start participating in politics. Secondly, the bill provides clarity in defining the concept of coordination. This is one of the more difficult concepts in campaign finance law. I'd be happy to talk about it in questions if people want it. Suffice it to say that now people, again, don't know when they're covered by the law. Certain things that you can do if you do them independently of a candidate somehow become illegal if you, quote, coordinate them with a candidate. And people find that, what's it mean to coordinate with a candidate? So a member of a group has worked with your office for years on an issue of concern to you as a legislator and to them as citizens. If they then go out and run ads saying, hey, here's a bill that we think is really great, have they coordinated with you? Does this make them a PAC? And that's the kind of question that's not known. And again, 2391 does an excellent job, I think, on the whole, of taking care of that issue and providing necessary clarity there. There are a couple drawbacks to the bills, things that I would actually improve, and are worth just mentioning quickly. One is that the bill provides a $2,500 threshold to become a political committee. That's too low, I think. The 10th Circuit, which includes Kansas, the United States Court of Appeals for the 10th Circuit, has held that a Colorado law that made a group of political committee for spending less than $3,500 was unconstitutionally low and was too much of a burden on grassroots speech. I think that 2,500 threshold should at least be doubled, which it would be if you adjusted that Colorado decision for inflation. And then, like all the limits in your act, it should be adjusted regularly for inflation, hopefully straight in the legislation. Similarly, you have your threshold for reporting donors' identities and names, their employers' addresses. All this goes onto the web, right? Starts at $50. I don't think any of you thinks you're going to be corrupted by a $50 donation, and I don't think any of you thinks that knowing who gave $50 to your campaign is really going to help the citizens of Kansas kind of understand finally what you're all about. So that number, which I think goes way back in the law and has never been adjusted for inflation, should probably be dramatically raised. At the federal level, currently it's 200, and that's way too low. I would substantially raise that threshold. Finally, the bill does not provide additional guidance on when groups have to report their donors if they make independent expenditures in a campaign. I think for a number of reasons I can go into in questions, the best rule on that is that if a group makes independent expenditures, it only has to report its donors who have contributed money for those independent expenditures, unless the group's a PAC. Of course, if the group qualifies as a PAC, it's different. But groups such as the National Association of Realtors, the American College of Ophthalmologists, these are two of the largest, quote, dark money spenders in American politics. These are just groups that spend money to talk about public issues, right? People join them and they don't necessarily favor everything those groups spend money on. So when you start requiring those groups to report all of their supporters, members, and donors simply because the group runs an ad, note the group would have to disclose they ran an ad. You know, the National Realtors ran the ad, but it's not necessary to report all of their donors, and indeed will often be very misleading to the public and intimidating to those donors who don't want to be singled out, open to cancel culture, harassment, and things like that. So you asked me to try to stay under 5 minutes, and I'm probably already over. But again, I thank you for having me here, and I'm happy to answer any questions at the appropriate time.
I'm a professor too, so I forgive you, sir. Thank you very much for your testimony. Our next proponent is, does David Keating have something to add as well? Okay, hearing nothing.
I just want one quick thing, which is from what I understand from the Fresh Vision controversy, one of the problems is that Kansas law has a $0 threshold for becoming a PAC, which is pretty much crazy when you think about it. A husband and wife, if they went to a campaign rally and bought a poster board and put a marker on the sign saying Smith for Senate, held it up at the campaign rally, that means they're a PAC under the law, which is an absurd result. If you had a reasonable threshold, as Brad suggested, it's quite possible this whole controversy with Fresh Vision would never have come to pass because they spend very little money.
Thank you, sir. Our next conferee is Ryan Kriegshauser. Welcome to the committee.
Actually, if I could defer to James Muir, our clients, I just want to make sure they have their time. So
Okay.
As an attorney, I'd take up too much time. I just
All right. Yes, sir. Our next conferee then is Ms. Tao. Did I say that right?
Thank you for having me. My name is Chinny Tao. I'm a proud Kansan for the past 8 years. And I'm here today as an advocate for HB 2391. But before I jump into that, I want to tell you a story. I'm going to tell you about the nightmare that Mr. Skoglund put us through, Commissioner Sobak, and the rest of the Kansas Ethics Commission. As I tell you this story, you will see the complete lack of accountability for their many unethical actions committed against James Muir and I. This is bullying at the political level at the expense of constituents. As the House Elections Committee, I want you to help fix this issue by holding this commission accountable through the laws and the courts. Fresh Vision OP is a small neighborhood social organization. It is a 501c4. It's made up of neighbors who are doctors, lawyers, farmers, and teachers. And we advocate for safe neighborhoods, quality schools, and thoughtful development. In January of last year, the Kansas Governmental Ethics Commission falsely accused our neighborhood group of being a political action committee. Despite providing proof of our 501c status, the commission went ahead and conducted a very biased hearing on March 23rd, 2021, and they deemed our group a PAC. During this hearing, James Muir and I both represented ourselves. We don't have a lawyer, and we're not lawyer ourselves. At the beginning of the hearing, I asked Commissioner Sobak, is Mark Skoglund a licensed and practicing attorney? I asked this question because he did not appear to be knowledgeable with the basic laws of a 501c4 versus a PAC. I was surprised when Commissioner Sobak insisted he was an an attorney licensed to practice in Kansas. During no point did Mr. Skoglund ever correct him. As a matter of fact, there were many points during the hearing where Brett Berry asked Mr. Skoglund to give his legal opinion based on his experience as an attorney. Point blank, Mr. Skoglund was dishonest. I verified his licensure 30 minutes before our hearing via the state website as a constituent because it didn't seem right that he was not aware of what the laws were or the rules and the guidelines. And I found out it was suspended. Here are the facts. His law license had been suspended for 7 years. This is a fact that neither the commission nor his own agency lawyer knew about when they presented him as a licensed attorney during our hearing. Here's where the bullying comes in. Commissioner Solbach shuts down my line of questioning about his attorney status and refuses to put him on oath. But yet, he puts all of us on oath. So, legislatures, that's an example of a double standard. So clearly, the Ethics Commission made their ruling prior to our hearing. They wanted to send a message that they are the judge, jury, and executioner. Let me remind you, this issue has never been about whether Mark Skoglund should be a lawyer or if the ethics director should be a lawyer. This has always been about the fact that Mr. Skoglund purposely allowed the commission to paint him out to be someone that he clearly wasn't. And to this day, Fresh Vision OP still has not received an apology for their actions. Apparently, the Kansas Board of Discipline of Attorneys thinks differently. My lawyer, Josh, received a letter informing him that the Office of the Disciplinary Administrator issued a letter of caution to Mr. Skoglund about his actions in our case. So here's the multi-million-dollar question. And this question is for the Kansas Ethics Commission. How can you fairly and objectively apply campaign finance laws and rules if you allow your own staff to misrepresent themselves? And in my case, apply the rules in different ways to different people. For the past year, the commission has made our lives difficult. They have drained our pocketbooks, all because we had the cojones to advocate against a concert venue being built in our backyards. They lied to us as constituents, they bullied us, and most shockingly, challenged our freedom of speech, the cornerstone of our great country. This is why I came here, because of that. The freedom of speech gives us this right, and it gives us this right to speak without any repercussions from the government censoring us. And in this last year, our group has been treated like criminals. And we have been subjected to threats of subpoena for personal and financial records. As I stated earlier, we are simply neighbors who are farmers, social workers, and business owners, and we are advocating for the good of our community. Our story is an example of bullying, censorship, and clearly a misuse of power. If this can happen to us, it can happen to any constituent, and it can happen to any one of us in this room. Every person in this room should know what I'm going to bring up. And this is really important to me. If you don't know what this is the scale of justice. It symbolizes the balance between truth and fairness. Let this serve as a reminder that justice is meant to serve all people, regardless of race, gender, religion, or political affiliation. We should never let the scale of justice be wrongly tipped to our biases. So I am testifying here today as an example of how the current Kansas Ethics Commission misused its powers. This legislature needs to increase the checks and balances on this Ethics Commission, and HB 2391 is a good start. Thank you.
Thank you, Ms. Tao. Thank you for coming to the committee. Our final proponent before we start questions is Mr. James Muir. Is that correct? Welcome to the committee, sir.
Thank you so much. Thank you for inviting us, allowing us to speak. I'm going to try and keep my comments a little bit briefer because they're pretty much being covered. So I'm just going to add in a few things that weren't in that. Like Chindy said, we are a 501c4 social welfare organization. And our vision, what we're there for, is to better the quality of life and keep the quality of life in South Overland Park, Kansas. Three of the issues that we focused on, which are diametrically opposed by several members of the Overland Park City Commission, are the uncontrolled commercial development within Overland Park. This includes the use of star bonds for commercial developments. One in particular by us is the Price Brothers Blue Hawk development, where they impose an additional 1% sales tax on all purchases made within that development. The interesting thing, as I talk to our neighbors, they have no clue they're paying this additional 1% sales tax. Also, the use of chip seal. If you don't know what that is on our roads, they just throw rocks on the road and the cars are supposed to drill them into the road. And that causes a lot of damage to cars, especially when you're driving down that road with the amount of semis that are throwing the rocks up. And the third thing is the conversion of US 69 in South Overland Park to a toll road. The main thoroughfare from South Overland Park moving north into Kansas City, they want to make a toll road. That would be the only toll road in all of Johnson County. That's what our focus was on it as a group. Now, our complaint was brought to the X-Commission by somebody by the name of Chris Newland. Chris is a former Overland Park City Council member. Former because he did not align with the vision of quality of life in South Overland Park that the people there have. He was a supporter of the uncontrolled commercial development. He got voted out of office. And he knew he was going to get voted out of office because before him, Richard, what was Richard's name? I think it was Richard Scott, can't say for sure. He got voted out of office for the same thing. He did not represent the ideas of quality life in South Overland Park. That's what we were through. Now, as Chinley and Josh said, we went through, I'm going to say hell, okay? And I'm going to tell you the hell I went through. I grew up with parents that told me your principles are the most important thing, no matter how much they cost. Do you know what they cost me? They cost me over $22,000 to defend this action with the Kansas Ethics Commission, for them to dismiss it with prejudice, with only the fact that we had to give up our right to go after them. So I had an interesting conversation with a friend today. Does not live in this state, but I told him what went on. And he came back to me and he goes, "This is what I feel you went through. You were headed home from the airport and you were pulled over by the police for going 3 miles an hour over the speed limit. The police officer asked to search your car and you refused. He then places you in handcuffs and puts you in the back of the patrol car. He then searches your car, which includes the luggage that you're flying with in your back seat. He opens the luggage up and you have an open bottle of whiskey in the luggage. So he arrests you for having an open container. The case goes to his lieutenant, who prosecutes you. He's the prosecutor. The case then goes before a judge, which is his captain. The jury is made up of the command staff of the police department. And you're given 2 options. Plead guilty with probation and community service and agree not to sue the officer or the police department, or fight the case in which you will receive prison time and a fine. He said, that's what you went through. And he said, does that sound like the United States of America? And I go, no. He goes, does that sound like China or Russia? Yeah. I did my master's work in international political economy with a concentration in Soviet studies. It certainly sounds like the Soviet Union to me. That's what we went through. As for Mark Skogland's unethical behavior in not stating he did not have his law license, I grew up in Michigan, outside Detroit. My wife, on the other hand, grew up in Seneca, Kansas. And we chose Kansas as the state to live in. I know several people who graduated from the University of Michigan's law school, Mr. Skogland's alma mater. And when I told them what went through, they laughed. They were so amused. They go, no, this guy had a law license and he was a graduate of the University of Michigan and he let it lapse for 7 years. They laughed at him. The fact he did not state he was not a licensed attorney when that was put up in that meeting, they laughed at him. This is his colleagues from his alma mater, the University of Michigan. The final thing I want to say is I've read some media on this. And what I'm getting from the media, this is a Republican and a Democrat issue. The two of you are fighting. The two of you are fighting. This is not an issue of that. I'm not a Republican. I'm a registered libertarian in this state and have been. Chin Knee is a registered Democrat in this state. We're not Republicans. We don't support Republicans in this matter. We support the people of the state of Kansas in this matter. And I want you to put the party politics aside and look at it. The person who just said what needs to be fixed, and fix it. Why did I have to spend over $22,000 to defend myself? Do you know how much we raised? Fresh Vision OP? Just over $3,000. That's the huge political action committee that the state of Kansas had to take down. Now, when the elections hit, I know the people running, one of them was a Democrat. Now, in the city, you can't say that, but we know he was. And I voted for a Democrat for mayor. And I am offended when people say this is an issue of the Republican Party. In no way is it that. Thank you so much for the time.
Thank you, sir. Thank you for your comments. Committee, I'll direct your attention to a written-only proponent testimony from Mr. Chet Compton. I'll ask, before we open up for questions, is there anybody else wishing to speak as a proponent? Mr. Kriegshauser.
Mr. Chairman, yeah, I just wanted to defer to our clients. I'll try and be brief. I submitted a fairly significant packet to you, and I just want to follow on those last comments. This is not a Republican versus Democrat issue. This is a bipartisan issue, and what we need is clarity in the law. And we have been watching news stories about some cases happening over in Shawnee County District Court where we are actively seeing the law rewritten before our very eyes. And the law in particular is KSA 25-4154. And the applicable provision just simply says this: no person shall make a contribution in the name of another person, and no person shall knowingly accept a contribution made in the name of another person. That's it. That's the extent of what the law says. And we've heard in public court statements, the Ethics Commission say that this actually means you can violate it without giving or receiving money. You can violate it by making suggestions on how money should move through the political system. Basically, if you make a suggestion and it has the effect of somehow circumventing campaign finance laws, you are in violation. Now, I put in my testimony some examples. I think Director Skoglund actually called the situation there a fairly conventional straw donor scheme. So he called this a straw donor scheme. In my testimony, I point out some other straw donors. The Kansas Democratic Party has 4, the Victory Funds, and then you have the Kansas Democrat Party. You are able, as a Democrat PAC, if you're just a Republican PAC, you get $5,000, but if you're a Democrat PAC, you can contribute to each one of those Victory Funds, and then you can contribute to the Kansas Democrat Party. You can give $25,000 as a Democrat PAC, but you can only give $5,000 as a Republican PAC. And all of that is marked out in the testimony, and I included the Campaign Finance Act reports. And I'll just direct you to one in particular at the end, because I know we don't have a lot of time here. United Democrats of Kansas actually put in their campaign finance report that they are structuring this money to allow a PAC that's limited to $5,000 to give $25,000. On their expenditure on October 19th, 2022, and on September 20th of 2022, they list 2 contributions, both to the Kansas Democrat Party. One actually says in the description, donation contrib divided among 3 separate KDP political committees. And that was for $15,000. And then the next one says donation contribution, Joan Wagner, $10,000. They gave $20,000 to the Kansas Democrat Party. Now, is that wrong? Is that illegal? I would say no, it's not. It's not illegal at all. And I don't blame the Kansas Democrat Party setting up their structure like this, just like I don't blame a CPA telling someone how to minimize their tax liability. If they can do it and it fits the law, they can do it. It's legal. It's not illegal to follow the law. Those have contribution limits. They set it up in that way. It's legal, but not under Mark Skoglund's new definition. That would be straw donors. And you go through and you look at the donations on each of those victory funds, they're almost identical. I mean, you can just go through and look at the contributions, like an instance is Sarah Baum. She gives $5,000 to each of those victory funds and then $15,000 to the Kansas State Democrat Party. She gave $35,000. Victory Fund 1 and Victory Fund 4 bundled those donations and gave them to Governor Kelly. There were no other there were some minor other contributions, but the majority, Victory Fund 1 in that period gave $150,000 to Governor Kelly, and Victory Fund 4 gave $50,000 to Governor Kelly. So that one individual who was limited to $4,000 in a campaign cycle, had she given directly to Governor Kelly, 2 for the primary, 2 for the general, was allowed to give $10,000 through, as Mark Skoglund calls them, pass-throughs. They touch these victory funds, and then they can go to the governor's campaign. You have House campaign committees for candidates that cannot give directly to the governor. They pass through the victory funds, and they can go to the governor. Again, I'm not saying that's illegal. I'm saying the Democrat Party is smart. But Mark Skoglund's new definition affects the Democrat Party way more than it does the Republican Party, because we've lived under this nightmare of him reinterpreting the law for the last election cycle. The Democrats haven't. And so that's why we're here today. If anyone's going to tell us what the law is, it's the legislature. We shouldn't have a bureaucrat in court just making it up as he goes, which is what's actually occurring if you read the news stories. We actually don't know what the law is because it's in the mind of Mike Skoglund. You'd have to ask him. But based on what he said in court, those victory funds would violate his straw donor pass-through scheme. So again, this is not...
Stop you there, Mr.
Yep.
Kriegshauser.
Yep. Thank you.
So we got plenty of time for questions. So does anybody have any questions for any of the proponents? Representative Neighbor.
This is for Josh, please. Since most of the people in here are not lawyers, would you define dismissed with prejudice? Tell us what that means.
Yes, there's 2 categories of a dismissal: dismissal without prejudice and dismissal with prejudice. With prejudice means it cannot be refiled under principles of double jeopardy or res judicata. It's already been litigated. Without prejudice is something that, for example, if I bring a suit against you for Representative Proctor for disorderly conduct, and my witness doesn't show up for the hearing, I may have to dismiss that case, but I still have 5 years to refile that. But with prejudice means that it has been litigated and that it's dismissal without being refiled.
Thank you. And one more question real quick. James. This is a point of clarification for you. Highway 69, you can drive on it and pay a toll in the fast lane, or you can use the slow lane and not pay a fee. Just so you know. Thank you.
I'm going to say to you, wait to see what happens with people in the slow lane.
Let's try to keep it to
Fast lane.
2391, folks. No, thank you. Thank you. Okay.
I have one clarifying on that. I'll make it very quick. This actually came up in the case. It's on page 4 of the PowerPoint, where in the settlement negotiations, Commissioner Scharnhorst said, would your clients be amenable to dismissal without prejudice? And I said no. He said, okay, and why is that? And I said, they don't trust you. He said, okay, any other reason they're not trusting the commission, they want some finality. And you can see, well, the other 1% I'll try, but 99% of the case is just the breakdown and the bone-on-bone litigation strategy. And so ultimately, as someone who owes a fiduciary duty to these 2 clients, for me to negotiate a dismissal without prejudice, leaving the option for the commission to come back at a later date after my engagement letter and my representation has expired and file the same thing within the, oh, by the way, what's the statute of limitations for Mark Skoglund to file a complaint? He says there's 0, 20 years later. So that's one of the provisions that I ask you to take up. For the AG and DA to prosecute the same allegation as a Class A misdemeanor, 5 years. I think it should be 2 years for administrative fines because that would track the general election cycle, 2 years after the election cycle, if that makes sense. Thank you.
Representative Miller, did you have a question?
I do, but Can I reserve the right to ask the proponents questions after we hear from the opponents? Because some of my questions may get answered in the interest of time.
If we do, I don't want to go to 7, but
No,
if we got the time, yeah, absolutely. Representative Woodard, did you have a question?
Thank you, Mr. Chair. This is for Josh. Thank you, Mr. Chair. This question is for Josh. Thanks for your testimony. You know, there's a lot in the bill, and I think some of it addressed this mostly irregular committee hearing that we've had. But there's a lot of provisions in there, some that I like the child care expenses for campaign and office holding. But so just a couple of questions as to, you know, how it relates to what you're doing, why this bill is so broad for things like okaying legislators to run PACs, candidate campaign dollars being able to go to PACs, and then some clarity on the intent behind gifts to volunteers and staff. As written, I could, in theory, my 2020 race cost $120,000 that cycle. If I raise $120,000, can I buy my volunteers cars?
Those are great questions, and I'm glad we're having it in this building, that discussion. Let me start with the PACs. That, frankly, when I drafted that, I thought I was strengthening that. I thought I was saying, not only can you not establish a PAC, but oh, by the way, you can't be a chairman or a treasurer too. I think we had an issue several years ago where a legislator joined a existing PAC as a chairman or a treasurer, which again, that comes down to agency. These are all tied together. I really hope you don't throw out one and not think about how it affects the other. Agency is a very huge principle in this bill. And so the question with coordination, the question with giving in the name of another, question with pass-throughs, all these things that we're talking about that are novel interpretations have to do with who's responsible, who has the discretion. If you say to me, hey, Josh, I'm going to give you $5,000 out of my campaign, I really hope it gets to these 3 candidates. You make that suggestion. Well, not only are you going to be rung up by Mark Skoglund, but the question I would have as a lawyer is, what if I say, oh, great, thanks, sounds good. Do I have any legal responsibility to spend that money how you asked me to do it, how you suggested? Did you have free speech in suggesting that? So the idea of agency informs not only the idea of who's liable, and whether you have a power of attorney or whether you have legal ability to bind someone, but also goes to the PAC question as well, that if you go to I don't know if ACLU has a PAC, I'm sorry, I do more law than I do politics, but if you go to, you know, a PAC and that you support and you solicit and fundraise and are a speaker at that event and say, hey, I want you to give to this PAC. They support good things. Is that coordination? Is that you participating in the activities of a PAC just by soliciting money? No. I think most all of you attend dinners that you support. And so this clarifies that really it's not participating in the activities, it's whether you have a principal and legally binding official capacity with that PAC. So I thought I was strengthening it. If I didn't do it, by all means, you know, chop it up.
Thank you, Mr. Chair. Just a quick comment. I think this committee has done plenty this session already to prove that we work in a bipartisan manner. There's, of course, going to be some things we disagree on. So I take a little bit of ouch from one of the conferees, but know that whatever we do going forward, I do believe we oftentimes do work in a bipartisan manner. Thank you, Mr. Chair.
I agree. Representative Howerton.
Thank you, Mr. Chair. I don't know if this is a question for the revisor or maybe one of the attorneys, Mr. Ney. Just can you clarify for me, is there a statute for ethics and then there's an ethics code? Or is it all is everything in ethics in statute? Do they write their own rules and regs, basically, or something like that?
Like most administrative agencies, you establish them by a statute, and then you give them jurisdiction over substantive law. And then within those substantive laws, statutes, there are procedural regulations. And then you may choose to pull in Civil Procedure Act, Administrative Procedure Act, Anti-SLAPP, Public Participation Act, or the Judicial Review Act, you might apply other general statutes to it. But in this case, it's Chapter 25, that's the Campaign Finance Act, which is within the elections chapter, as well as Chapter 46, I hope I'm getting that right, which is the governmental ethics that are your and my substantial interest forms. Those are what legislators can and can't do during session, the types of gifts that the executive branch employees and legislators can receive, and then lobbying is regulated through Chapter 46. The administrative agency then is empowered by you to make rules and regulations to further define that. In a lot of places they've done that, including the major purpose test, which is currently unconstitutional, but sometimes they haven't. Like on the giving in the name of another, we have basically zero guidance on that. There's a ethics opinion going back to the 90s that basically says nothing, and frankly is arguably an unconstitutional opinion if that's really how broad it is. All that to say that, yes, sometimes there's clarity in rules and regs. There's also advisory opinions that they can issue. How those function are staff can recommend through talking with you all or talking with us, hey, we should clarify this. The commission can direct staff to prepare an advisory opinion. Once it's prepared and then approved by the commission, there's a presumption that if you or I act in accordance with that advisory opinion, that we're not violating the law. So it's an evidentiary shift, burden shifting at that point.
Follow-up, if I may?
Go ahead. We need to move along, though.
Yeah, so who reviews those? Like for an organization or, Department of Agriculture, they do rules and regs to enforce the law, and then it's reviewed by the AG's office, and it goes before the Rules and Regs Committee?
It's the
same process. Okay, thank you.
Rules and regs. Advisory opinions, there's no public comment. It's just staff and the commission. They make
Josh, just a second. I got a follow-up question here. So for the non-lawyers in the room, if I'm a county attorney and I'm investigating a crime, what do I have to go through? If I'm investigating or I'm prosecuting a crime, what do I have to go through to get a subpoena?
So subpoenas pre-complaint. Again, we're talking about pre-complaint versus post-complaint, and that's important when understanding what the previous provisions, 2289 or whatever it is that have been adopted into this, and then the 4161, 254161, where that subpoena power has been preserved. Similarly, at the county level in criminal procedure, in order to investigate, you can get a search warrant pursuant to the Fourth Amendment and statutes under Chapter 22 criminal procedure, where my sheriff's detective would go to a judge, say, here's my probable cause, here's where my specific place I want to search, and this is why I think I have probable cause for the fruits and instrumentalities to be found there. District court judge reviews it, signs it, issues a warrant. They can go search your underwear drawer and your cell phone. That's a search warrant. That's probable cause. There's also what's called a judicial inquisition statute that allows me to apply to a district court judge as a duly elected county attorney, ask them to, the district court, to allow me to open up a case that would be confidential based on a proffered basis of my suspicion that a law has been committed, establishing probable cause at that point, and then once he signs off on my application for an inquisition, then I have the ability to issue subpoenas or ask the court to issue subpoenas. Everything's reviewed by the court and issued by the court at that point to be able to subpoena certain records. That would be bank records. Usually it's bank records for white-collar crime. That can be cell phones. I can even haul people into the witness stand for a deposition at that point. They haven't been charged with a crime, but I can do that. But all of that is supervised by a district court judge. I don't get the unilateral authority to just issue them, if that makes sense. The reason I think that's important for the judicial inquisition being applied here is that in certain circumstances, when you've got core fundamental constitutional rights at play, Fourth Amendment rights at play, district court judge. First Amendment rights at play, especially all of your text messages. If I took this basket right here and I just asked you to hand me your cell phone so Mark Scoglin can go through them today, and by the way, preserve them all, or you may be held in contempt of court at some point. Would you feel comfortable about that? Would you feel comfortable if, even though you're not accused of wrongdoing, you can still be brought into an investigation and have them rifle through your text messages that you might have just said something mean about your colleague or your adversary, or people joke all the time, and so that's why the courts have created this idea of First Amendment privilege for a court to review that at that point. That's why I think at the front end, it's a kangaroo court for the commission, that they're not experts in this area of law, to try to play constitutional lawyer. They're not constitutional lawyers. I think that they're well-meaning. They're just not. Mark Scoglin is capable. He's a worthy adversary. He's smart. I like sparring with him. He writes great motions. We disagree on the law, but he is a worthy adversary. The commission is not. Judge Watson is.
All right, committee, we're going to have to move along here. All right, final question, Representative Dodson.
Yeah, when, Mr. Nye, when you got up, you talked about two things. One was process and one was the existing rules. I didn't hear anything on rules, and we don't have time to go over that, but I'd appreciate your thoughts on the rules that we don't have that might be changed or those that we don't need any longer. I will make a statement. I'm a little bit disturbed that we were retrying a case in here and we were using a person rather than just doing the facts, ma'am. So this is a strange tenor to a rather what is supposed to be a factual hearing.
All right, we're going to go ahead and move on to opponent testimony, and our only opponent that I've got listed is Mr. Mark Scoglin. Welcome to the committee.
Good afternoon. Mark Scoglin, Executive Director of the Governmental Ethics Commission. A couple things worth noting at the outset before I dive into my testimony. The proponents are focusing almost entirely on one hearing that doesn't have anything to do with 99% of the changes that are occurring in this bill. They are attempting to distract you from all of the things that this bill actually does, and it's worth paying attention. My testimony goes line by line through what occurs in the bill. I have footnotes that spell out exactly where these changes occur. This bill was drafted by an attorney who represents multiple clients under active investigation by the Ethics Commission. This bill would make the conduct these clients may have engaged in legal so they can continue that same activity. It is arrogant, it is brazen, and it is sad. The Commission calls balls and strikes. Thus, some people are upset that there's an umpire at all. Additionally, this bill includes many provisions that prevent the Commission from engaging in investigations, undermining a law enforcement agency at its core. It also includes provisions that are frankly nothing more than sheer retaliation. HB 2391 would virtually eliminate any point to having campaign finance law in Kansas. Even in the rare case that a violation could occur, they could never be investigated or enforced. A guiding light in Ethics Commission enforcement is that regardless of how powerful you are subject to the same laws as everyone else. If this bill does not fail, you are saying exactly the opposite. That powerful interests, who are not here today, when they violate the law, can simply change the law in response. So first, going through my testimony, this bill would legalize coordination with PACs. We have many ongoing investigations relating to many facts that are under these things that would be changing. Someone who makes decisions on behalf of a campaign cannot coordinate with a PAC that's supposedly expending independent expenditures on your race. That's a cornerstone of any campaign finance act anywhere in the country. This bill would define agents so narrowly that unless the decision maker has a power of attorney, which has, I would be shocked if there's any campaign anywhere that has given anyone a power of attorney anywhere in Kansas. Cooperation and coordination then become functionally legal in Kansas. The second is that it legalizes contributions in the name of another. Most situations when you have someone giving in the name of another, they're not usually doing it to hide the original source, they're doing it to exceed contribution limits. At the federal level, you hear a lot of times about investigations into a situation where a business, for example, has a bunch of employees donate and the business then reimburses all of those people their donation. This is giving the name of another to straw donor scheme, and they're doing it so they can give more. The business can give more than what they're legally allowed to do. They're not just hiding that the business is giving. And in these instances where they're trying to exceed contribution limits, they're doing so because they've already given the maximum and they want to route funds through other entities in order to exceed those limits as well. There's frankly no reason to have contribution limits on the books if you can just pass money through other entities to ultimately be given to a final entity. It also, in case it's unclear what this bill does, it also amends the statute prohibiting excessive contribution limits to allow exactly this to occur, to pass money through other entities in order to exceed contribution limits at the end. This bill also legalizes passing candidate funds through other groups for other candidates. Obviously, anyone can give to your party at any level. You can give to your party. But what you can't do is say, if I give you $5,000, will you spend it on this candidate? And then you do that. That's not an appropriate use of your campaign fund. The campaign fund has very specific uses that what you can use it for. And one of those is not making an expenditure on another one's campaign. Therefore, the only prohibition that 2391 has in this capacity is that earmarking cannot be contractually restricted, which again, has never happened in the history of campaign finance anywhere in the world. Next, it legalizes legislators running PACs. I do want to say I appreciate Josh's clarification earlier, and we definitely support a prohibition on serving as a chair or treasurer. The situation he's talking about is one that I agree. It has been problematic for a long time, and fixing that is something that is very good. I will say that the way this language is drafted, it creates a universe where it allows someone to participate in the activities of a political committee, even at the establishment phase, which is very confusing and creates a conflict that, frankly, we don't know how to resolve. It also prevents enforcement of violations that are currently under investigation via a 2-year statute of limitations. A 2-year statute of limitations, frankly, is absurd. We have a part-time investigator. We have 8.5 total staff. The FEC, who actually has the capacity to do massive investigations, has a 5-year statute of limitations. We certainly don't have that kind of capacity here, and any massive complex campaign finance investigation is very difficult and does take some time. I will also note that we have multi-agency investigations, that if we have a 2-year statute of limitations, it creates a situation where we are required to either move first, which destroys and undermines an investigation that other people are conducting, or frankly, don't enforce the campaign finance component of that investigation at all. That happens more than you might think. It also limits fines in situations with many violations. I believe proponent testimony alleges that this occurs because we stack counts. I think there have been 2 complaints in 5 years that have more than maybe a few counts. I can't really recall any other situations where there would have been several counts. And only in one of those instances was part of a consent decree negotiation to essentially combine counts. It's only happened once in at least the last 5 years. So certainly it's not widespread. Starting on page 4, undermining our ability to investigate violations. Obviously, the big one here is eliminating our subpoena power. Essentially, without a subpoena power, we don't have all the resources that many law enforcement agencies do. We basically have the ability to have people come talk to us, or we can subpoena them. We have other situations that we can try to get some compliance, find some reports, things like that, but really these are our only mechanisms for investigation. Our subpoena power is entirely dependent on judicial oversight. If we subpoena you and you don't respond, all we can do is go to court and ask them to enforce it. And what happens there is they evaluate, they make sure a few things are true. One, that it's actually legally supported, that we're not trying to get anything that's not relevant to an investigation. So if a subpoena is overbroad, it's limited at the judicial enforcement stage. If there's any other issues, maybe the subpoena is entirely unsupported, it gets quashed. We have judicial oversight already. That already has to occur. We can't do anything on our own in terms of what we can do with the subpoena. This bill would require proving probable cause without an ability to actually find evidence. It says that we can't issue subpoenas unless we file a complaint. We can't file a complaint unless we find probable cause, or we can't issue a subpoena unless we reach probable cause on a complaint. But how do we obtain that evidence in the first place? It's putting the cart before the horse, and this is intentional. Eliminating investigative subpoenas also prevents enforcement where a party is unidentified. I can think of at least one instance in the fairly recent past where a text message lacked a paid-for attribution, and if it had expressed advocacy in that text message, we would have had to find out who the origin was. If we can't have an investigative subpoena, it's just not possible to do that, which means we can't ever enforce the act. A possible outcome here is actually the filing of more complaints. We usually don't try to file complaints unless we have to, but here we would have to file complaints. Being able to request inquisitions, frankly, is meaningless. This committee has already noted, even during my annual report presentation, that the offices that we're talking about potentially doing an inquisition on our behalf don't have the time, personnel, or funding to handle low-level white-collar misdemeanors, sometimes the lowest misdemeanor that is even under the law. This is an expansive process, and frankly, they don't have the time to do it. To the extent that perhaps, I know the Attorney General submitted a fiscal note, there is a perception problem here, regardless of who the Attorney General is, and I have no problem with working with any Attorney General, but there would certainly be a perception that if we can only do inquisitions through the Attorney General's office, that's a partisan elected position. And realistically, it would be at their discretion. It would be reasonable for the public to be concerned about a partisan influence at a critical stage of an investigation. Last, on subpoenas, it prevents us from using our subpoena to assist candidates and committees. The number of times that a candidate or committee has come to us and said, we need to fix our books, but the bank will not give us our records without legal process. Well, we can do that. We've done that before, and we'd do it again if this bill doesn't pass. This bill prohibits witness cooperation agreements, which is a little odd. I think the underlying concern is if we implied that we could give immunity from the criminal component of most of our laws, which we can't do. We can only give immunity for the violations under the act, so the administrative fine component. If that's the concern, then this isn't the language that should be used. The language should say that any such grant of immunity needs to specifically include text that says you are recognizing that we cannot give immunity for any criminal prosecution should a DA or county prosecutor so desire. That'd be the language that we would use, but instead this shuts out our ability to gain cooperating witnesses at all. This also creates a pervasive threat of large costs of any investigation. The Public Speech Protection Act, the anti-SLAPP law, already applies to anything that is a claim by the agency. So if we, for example, if we have to go to district court to enforce anything, that's a claim, and it's subject to the Public Speech Protection Act already. This expands that, so any action that the commission engages in is somehow subject to the PSPA. And what that does, to be clear, is if we don't have substantial competent evidence, then we could be subject to massive attorney's fees. And let's be clear, our entire state agency budget is under $800,000. If that's the case, there's no way to gain substantial competent evidence because simply we couldn't make the calls to do initial investigations. There's also some major provisions that are fundamentally damaging to campaign finance law. Changing our standard of review to de novo is frankly shocking. We're subject to the KJRA, the Judicial Review Act, which includes, now I know Josh has mentioned one of the 8 possible bases for appealing, that if something were arbitrary or capricious, but there's 7 others, including that it's an erroneous interpretation or application of the law, and it's an action unsupported by the evidence. There's lots of bases that the KJRA already handles, and having the balloon amendment, which would have been nice to have at some point prior to today, the moment before speaking, it's interesting that they've added now an evidentiary hearing component to this. So now there's already, now that adds an expense, which is not included in the fiscal note, for any such hearing that we would have, that would be appealed. The PAC registration requirements are absurd, and I want to be clear about this. We absolutely support setting a minimum limitation, so very, very small PACs that only take in a few contributions or do some very few expenditures that they don't need to register. We support a minimum basis. We support having married couples being exempt because, frankly, it's absurd that they're not right now. I agree with that. Now, the problem is that this means that if 2 things are both true, they're required to register as a PAC. That they spend over $2,500 on express advocacy, which most PACs don't do. They make contributions to candidates. And they spend more than 50% of their total spending in a 2-year period on reportable contributions or expenditures. This means that not only, we wouldn't know anything until 2 years later. We couldn't enforce anything against a PAC until 2 years after the fact. And an organization that has an associated business could could essentially, at the end of a 2-year period, just make a massive contribution to their business, who could then in turn pass it right back, and no one would ever register as a PAC. There, frankly, would be no reason to register as a PAC ever again for any vaguely savvy organization. Being unable to provide fine reductions in exchange for specific performance also prohibits us from having, basically, when someone doesn't have a report filed, which is most of our fines, we can't say, look, if you filed a report within 30 days, we can waive your fine or massively reduce a fine, which means those reports would never be filed. We can't exchange it for training. So we can't say, if you do a campaign finance training, we'll waive this. We do that all the time in the ethics universe as well. If someone's received an overcontribution, we couldn't enforce it. Proponents focus on one specific instance where the attorneys for the respondent suggested community service as an alternative, and the commission, with some other requirements that were also added as well, ultimately said that was fine with them. I don't think that's ever occurred otherwise, but rejecting all specific performance shuts down many avenues of reducing fines. It also it prohibits us from reducing or waiving fines, which is a little surprising to me, given that most people like when we reduce or waive fines. There was one instance that we found out years after the fact that the treasurer who received a fine was actually a minor at the time. It was some candidate who had appointed his daughter without actually telling anyone about it. We waived that fine. This bill would not let us do that. We'd be holding someone for that. Now, there's a lot of other issues that we can talk about as well. I'm trying to be mindful of the time as well. I want to mention a couple other things from it, with permission. I want to mention a couple things that were brought up in testimony. And I will also note at the end of my testimony, you see that there's a couple things that think there's not everything in this bill is terrible, just most of it. Josh said that there was no judge, but KJRA applies. Anytime someone can always appeal an action by the commission. The Institute for Free Speech, I really appreciate them testifying today because we are currently ranked 6th in the nation in campaign finance law. I'm not sure why we would devastate campaign finance law in this way. We're 100% on campaign expenditures, 100% on regulation of issue speech, 80% on coordination, 100% on PAC registration. And yet all of these are things that are changed in this bill. My license was suspended for 7 years because I stopped paying fees and attending CLEs. I didn't think this was still an issue for anyone, but this is something that occurred. I appreciate Mr. Kriegshauser's testimony because it focused on some other things in the bill that have nothing to do with the Fresh Vision hearing. It's worth explaining some of this as well. If you give, like I explained earlier, giving in the name of another, if I give $1,000 to a Senate candidate, and then say let's say one of my friends, I say, I will give you $1,000 if you give this to that candidate. And they say, sure, and I give them $1,000 and they give that to that candidate. Well, that's giving in the name of another. That's part and parcel of what happens here. Now, I know he talked about some situations in which a state party, you can give, for example, money through other entities as long as you're reporting the original source and you're not committing excessive contribution, you're exceeding contribution limits at the destination. So for example, if for some reason, and some of you have gotten letters from organizations that have done this in the past, they say that you are receiving a check from entity A. In reality, this is money from entity B who has not given to your campaign. They're not at the campaign contribution max or anything like that. But this is money that is originally from them. That's legal. It's not being given in the name of another. It's being given in their name. It's being properly given. And they're not exceeding campaign contribution limits by doing so. So I can certainly take any questions at the appropriate time, but I appreciate the opportunity to be here. And if anyone has any questions after today, you also know where our office is.
Thank you, Mr. Skoglund. I'd direct the committee's attention to written-only testimony from Nicholas Hale, Jerome Helmer, Nikki McDonald, and Aaron Gould. Is there anybody else wishing to speak as an opponent on House Bill 2391? Okay, if not, committee, are there any questions for our opponent? Representative Miller.
Not that I think it's that relevant, but you didn't finish your thought. You are currently a licensed attorney.
I did get my license back, yes. It was just a matter of...
No, yes or no?
Yes, the answer is yes.
And secondly, the Fresh Vision case, as I understand it, was simply, the issue was that they spent money, it sounds like $3,000, expressly advocating or opposing a candidate, and you asked for them to supply the necessary paperwork to comply with the law.
I believe the count was that they had not registered as a PAC. And it was our assertion, or my assertion, that they should have registered as a PAC.
And that they qualified as a PAC.
Yes.
Because they had expressly abdicated the election or defeat of a candidate.
Because in applying the major purpose test outlined in reg, that yes, that they would have qualified as a PAC under that interpretation.
And that's what all the fuss was about.
Yes.
Thank you, Mr. Chairman.
Representative Howerton, did you have a question?
I did. Thank you, Mr. Chair. So we heard the FEC former chairman testify that you guys, we have a 65, right? And that wasn't great, but you testified that your scores were 180. Can you clarify that for me?
Yes, we are 6th in the nation. The score that they number is a 65. That is correct. And sorry, I don't know if you were shifting in your seat. I didn't know if you had something you wanted to add to it. Okay.
Sorry, I'm still in high school, like 100, like that's a D. So, so 65 is a good score?
I mean, it is ranked very well. I will note that many of the recommendations of the Institute of Free Speech are less transparent for the public. There's a concern, I think I won't speak on their behalf or say what their purpose is or anything like that, but many of the recommendations that they have set much higher limits for disclosure or say that certain things shouldn't be disclosed at all, things like that.
Are there any other questions for Mr. Skoglund? Representative Howell, do you have?
However, did you know, Chairman? Thank you. So I just want to make sure that I'm understanding. So just to clarify, it is your contention, and maybe this is common knowledge, but I've never thought of it this way, that the Kansas Ethics Commission is a law enforcement agency. Am I understanding that correctly?
We enforce laws, yes. The campaign finance laws are laws. We just issue civil fines, so we're an administrative agency. But it's hard to not think of us as an entity that is in charge. We're the only entity in charge of resolving ethics issues, lobbying issues, campaign finance issues. Frankly, and this is part of why, I'm glad for the question, this is part of why it's important that the commission does its own hearings rather than sending them off to OAH, because the commission is 9 people who are have strict requirements that are perceived to be nonpartisan. They are people who have expertise in campaign finance because, frankly, they deal with it every single day. So when we send off things to district attorneys and county prosecutors, and to be clear, we have to do this all the time, anytime we find a violation, we are required to notify DAs, county prosecutors, and the AG's office for some reason. The way that this works, I am unaware of the last time that any DA or county prosecutor has even considered prosecution of any action that we found a violation in. And that's worth noting, because relying on them for something like an inquisition, frankly, is just seems likely, given that they have not indicated any previous interest in pursuing these low-level misdemeanor violations.
Okay, one more, Representative Howell.
Thank you, Chair. So then my next question would be, is who or what agency is the KEC accountable to?
So anything that we do can be appealed to district court. Judges have oversight over everything from subpoenas to final orders of the commission. We're subject to the KJRA, the Judicial Review Act. All of these are things that we already have to do. So in addition, there's we can have civil action against the commission for any variety of other issues that they may decide. There's a lot of avenues for oversight, but the issue is the Ethics Commission exists largely independent as an agency. We're technically in the executive branch, but if we investigate the governor, for example, she can't fire me directly. And it's set up that way intentionally. It's set up so that we can be a check on policymakers, that people who are running for office, who are in office, we're oversight for all of you. But that doesn't mean that there's no oversight of the commission.
Mr. Vice Chairman.
Thank you, Mr. Chairman. Mrs. Skoglund, you criticized the notion of the bill to have a 2-year limit on subpoenas. And are you saying the only alternative is to leave it unlimited, or do you think it's reasonable to not have some sort of time limit on investigations and such.
No, I think that there's definitely room for some discussion there. I'm generally positive about the notion of statute of limitations broadly. The issue is figuring out exactly where that lands. I'll note that a 2-year statute of limitations shuts down many current investigations in progress today. It also, and I know that technically it's not effective until July 1st, but there's a lot of investigations that wouldn't be able to go anywhere. The 2-year window on PAC registration, which is PAC reports sometimes generate these sorts of investigations. We wouldn't be able to investigate those matters because we wouldn't know about them until 2 years after they occurred. And frankly, some very complex issues do arise in the campaign finance arena, and they take longer than 2 years to sort out, especially with a part-time investigator. Now, that said, and all that aside, I am positive about the notion of a statute of limitations, but I'd want to be part of that conversation rather than having this bill dropped on me 6 days ago. That's really the focus that I would want to work on.
Representative Miller, did you have a question?
Yes, thank you, Mr. Chairman. Not that it has anything to do with this bill, but it was brought up. What's the purpose of having these people sign a release, and is that common?
I think that's only happened once. I'm hesitant. It's only happened once in my tenure, but I'm very hesitant to say anything that happened in previous tenures without actually doing research on that. I can't speak for why the commission particularly wanted that issue to occur. The question that Commissioner Scharnhorst asked that was quoted to you, his point about without prejudice or with prejudice.
No. Let's stick to my question.
I am, if you give me a moment.
All right.
I'm sorry. His question about dismissing with or without prejudice, that was all about the fact that the commission wanted finality. And he said that there was a discussion about whether it was appropriate to have certain waivers. The commission said they also wanted finality. It said, if we're all going to settle this with this letter of caution, then we want to just walk away then everyone wants to be done with this issue. That's my understanding of the issue to the extent that I can speak on behalf of the commission. But that's the context for Commissioner Scharnhorst's comment.
But you don't know anything more than that?
I can't, this is, as far as I know, that's only happened once.
And we were told that this is not retroactive, doesn't apply to any existing cases, but I thought I read in your written testimony that you believe it is.
I believe that it would allow certain activity to continue unchecked. The bill, the actual statutory language doesn't come into effect until I believe July 1st. There's a lot of activity that is under investigation that would just continue in the current, that is currently under investigation. Additionally, it would create certain problems like a 2-year statute of limitations. We'd be tied up in court for years trying to resolve whether or not that applies today or not. 2 items that happened before. That's really the scenario we'd find ourselves in.
Representative Howerton.
Thank you. You said the word broadly, so I remember something that you said. You said the subpoenas that you issued were overly broad, but that the court would make them specific. So
let me clarify that.
Okay.
My comment was that if we issued a subpoena that was broad, the court would be able to constrain it. It's a motion to quash, essentially. And also, applications to enforce a subpoena are subject to the Public Speech Protection Act already. There's no need to expand the PSPA jurisprudence here. They'd have to prove that meets the first burden, which is that it negatively affects some sort of free speech issue, and then the burden would shift to us to prove that it would, that we have substantial competent evidence of a violation, essentially. That's really what would occur. But yes, the court has ultimate decision. They would be able to constrain subpoenas. In a universe where we've issued subpoenas that weren't quite as narrow as they should have been, we've come back in many instances and issued significantly constrained subpoenas in some investigations in the past. But yeah, at the end of the day, we can't do anything with our subpoenas unless a court tells us we can. And a court, frankly, will limit them to what is very, very specific under the law, under what is allowable.
So normal constituent, sorry, can I follow?
Go ahead.
So a normal constituent or normal person on the street, they cannot represent themselves. They have to have an attorney before you. Is that correct?
No.
Because they wouldn't know the law, that if you did an overly broad, they wouldn't realize that, right?
So if we issue a subpoena and they don't respond, at that point, we have the obligation to go to court to figure out what to do with it. They could show up to court and they can make assertions that, you know that.
I'm a good citizen, sorry. I would respond to you without even knowing, because I want to be ethical and I want to be seen as that, but it could not.
Sure, and if there are concerns that if someone
Not well for me.
communicates with us and says, for example, I have some documents, but there are, I think that you're asking for more than what you probably are interested in. We have conversations with them and say, okay, well, these are the things we care about. Let's make sure that that's all it is. Now, that said, again, we do work to make sure that our subpoenas are, when we do have to issue them, which I don't recall the last time we've, 2022 and before, or 2021 before, I can't recall the last time that the commission has had to use subpoenas to enforce, that we had to go enforce them in court. That normally it's fairly straightforward enterprise.
So are there any other questions for Mr. Skoglund? All right, so we're at 5:15, so I'm going to not dive into my questions about the commission's Twitter policy. I'm going to get right to the subpoena thing. How many subpoenas did you issue in 2022?
I wouldn't be able to answer that question. We generally don't disclose as much of an investigation as we can avoid.
Okay, so you said that it's been a long time since you had to go to court to enforce a subpoena, and you guys just did go to court to the Shawnee County or District Court, and the judge there, District Judge Teresa Watson, said that your findings of fact were legally insufficient and to demonstrate reasonable suspicion of a violation or something to that effect. Would you care to comment on that?
I wouldn't be able to comment on anything ongoing. I will note that I think that if the example you were talking about occurred, I think it's a great example of the fact that there's judicial oversight of the commission's investigative work.
So would you say, I think you just did say a few minutes ago in response to the representative that most people don't take you to court on the subpoenas.
I would say that it's been a while since we've had a complex investigation that required more than a few subpoenas.
Okay, so how many of those subpoenas you issued in 2022 were based on that same finding of fact that the Judge Watson just said was insufficient?
I wouldn't be able to answer that.
Okay, so all those people who didn't take you to court, if their subpoenas were based on the same findings of fact, and that did in fact occur, they would be, they submitted to a subpoena that maybe wasn't based on a reasonable suspicion. But why do you think most people don't fight you on the subpoenas? Is it because they're so rock solid? Or, I mean, why do you think it is that candidates, political campaigns, PACs usually don't fight you on subpoenas?
I actually don't think that it's a correct characterization to say that we're never fought on subpoenas. I think that subpoenas are used as an important part of an investigatory apparatus, and they're the only way that we can get certain evidence of violations. There's parts of the Campaign Finance Act that, frankly, there's no reason to be crimes if we can't subpoena entities. But, for example, bank records are a very common subpoena. We've had some back and forth with banks before, but typically they look at the law, they understand that we have an ability to go get those records. This bill would mean that we couldn't do that. We would never be able to get that information. We'd never be able to support the complaint to a probable cause stage without something like that. And this bill would eliminate all of that.
I think this bill says that you'd have to go to a judge and demonstrate that you had a reasonable suspicion before you could, and to get a subpoena. Isn't that what the bill says?
I hesitate to ever correct the chair, but I would note that it allows us to request an inquisition from a DA, county prosecutor, or the AG. It doesn't say that we get one. It also doesn't say that it doesn't provide any avenue for us. There's no guarantee of any actual investigatory work.
It doesn't mean that it couldn't happen. It just means you are concerned that it might not happen because they're busy with other stuff.
It would be a rather significant departure from past interaction on campaign finance issues with DAs and county prosecutors that they would suddenly be interested in assisting in an investigation in this capacity.
So I take to heart very much what the representative from Manhattan said, and I don't, this is not about Executive Director Skoglund. This is about the system, right? And your commission is engaged in regulating speech, a fundamental right. I mean, is that a fair characterization?
Campaign expenditures are speech, yes.
Okay, and so do you think that issuing subpoenas to candidates on a ballot or to political action committees or to parties in the middle of an election year has any kind of impact on elections?
I wouldn't be able to say.
Do you think that maybe the reason that respondents don't fight you on subpoenas is because they're afraid that it will have an effect on their campaigns? Or, I mean, do you think that, I guess what I'm getting at is, do you think that a subpoena has a chilling effect on speech?
I do not.
Okay, I differ with you on that. So, all right, so are there any other questions for the Executive Director? Mr. Vice Chairman.
Yeah, Mr. Skoglund, one of the comments that had been made that was probably most, I don't know, unnerving, but why on earth would you be subpoenaing people's cell phones? I mean, and text messages and such. I mean, that seems like a fishing expedition, seems very over the top, you know, for campaign finance. Can you explain?
Sure. So I can't confirm or deny that we've actually subpoenaed a text message. Leave that aside for the moment. But in a universe where we do, frankly, when you have, let's talk about for the situation of a quid pro quo, because I think that's the easiest case. When someone is given let's say a legislator is given a gift and says, this is in exchange for a vote on a particular, or a campaign donation of a maximum, and say, I'm only giving you this if you will vote yes on this particular item, and that occurs, that's a quid pro quo. That conversation occurs in communication mediums. I mean, who here does not use text for casual communication? And that's where quid pro quos happen. So that's an example of, without a text message or without the ability to subpoena certain very specific communications, then it's just not possible to enforce the campaign finance law in many aspects.
Do subpoenas on communication devices, are they not, I mean, can they not be just specified for a certain, you know, communication with this person or something? I mean, there's a difference between that, I think, and just handing over your cell phone and just whatever you find, you find. I mean.
I appreciate that question because it gives me the opportunity to make a good clarification. If you look at the subpoena statute, it is very specific that we can only get information that is reasonably relevant to the investigation. We can't just take your cell phone and flip through it. And if we ask for things that you believe are broader than an investigation, then a motion to quash in district court handles that rather handily.
Are there any other questions for Mr. Skoglund? So you started to touch on something, and I want you to circle back around to it if you would. You were talking about the instance where the punishment for violation was community service. Could you elaborate on that?
Yes, it was, to be clear, an odd circumstance, I think. There were two treasurers who were, had basically, we can only hold treasurers responsible for, not to start talking about Tuesday's bill, but we can only hold treasurers responsible for misreporting issues. And so during the hearing, the commission seemed to, I won't speak entirely on what was going through their heads, but based on their comments, it seemed like they believed that the treasurers were volunteer treasurers in a bad spot, that they probably should have known better to sign these statements, but at the same time, they are the only people that can be held. So an attorney for one of the respondents, I believe, originally made the request that perhaps in lieu of a fine or in favor of a fine reduction, they could engage in some sort of community service. I think it was me who made the point that I would prefer something that has something to do with the Campaign Finance Act more directly, and so they added on a requirement to send letters to treasurers, other party committees, essentially warning them of what occurred here in that particular issue and make sure that they know to avoid it going forward. So that was also one of the other requirements. But yes, they ultimately did say that we'll issue a fine and we'll reduce it if you engage in a certain amount of nonpartisan community service.
Do you know what the community service was that they ended up doing?
I do for one of them for sure. I believe the other one also sent the documentation as well. But yes, I do have that.
Right. Can you tell us? Is that public?
I can send that to the committee. I don't have it off the top of my head.
Okay. So how do you Do you understand how, for the proponents of this bill, there's a perception of an uneven application when these two guys, because it was a really big dollar number of money that was misaccounted, got community service, and I believe it was door knocking doing voter registration, which is sort of something their organization's okay with anyways. But the Fresh Vision OP folks got drugged through the ringer for $22,000 worth of legal fees before they finally got let go.
If you give me a moment, I can tell you what the community service.
Okay, thank you.
But I will also note briefly that in the discussion on community service, as I think Mr. Nye noted in his testimony, that the ultimate discussion, that the original discussion just said community service writ broadly. Someone else had mentioned voter registration, and I had made the point that that perhaps they need to be very careful and ensure that it was nonpartisan in nature and that it had to be, because otherwise, obviously there are issues that would occur there. And let me see, I have it here. So for one of the respondents, the volunteer, it was actually more than was required, but it was Braided Haven, Topeka Police Department, Washburn University, and the Washburn University School of Law were the 4 areas that were completed for 16 hours.
So, but to my question, which is, do you understand how there's a perception that there's an uneven application of justice when these guys get to go do that? And the Fresh Vision OP folks, who ultimately were found to not have violated the Campaign Finance Act, got drugged through the ringer for $22,000 worth of legal fees before that finding.
A couple of clarifications. First, we did not to rerun a hearing, we did not find that they did not violate the law. We ultimately dismissed the matter with prejudice as essentially in exchange for a letter of caution. I'm hesitant to have extensive commentary about a hearing that occurred like that, but I will note that ultimately the only request from the commission originally was that they register and file the required reports. After they came back and after further discussion, the commission ultimately dismissed the action. It wasn't a finding that they were not a PAC, it was a finding that perhaps a letter of caution was a better approach here. So.
Okay.
There was at no point a discussion of a fine or anything like that that was necessary.
What I'm trying to get at is, you don't feel like these investigations have a chilling effect on speech, but when everybody looks at Fresh Vision OP and the fact that they got, they got drugged through the coals for $22,000, that really makes me kind of want to shut up and not want to say stuff, or not want to contribute to this, or not want to spend money on X, Y, or Z just in case, because even if I am ultimately successful, even if I do go to court and win, it's going to cost me a fortune.
I think it's important that we have, most states, as far as I know, most states do not have a minimum limit on PACs. I don't actually know if it's a majority, but there are lots of states that do. In those states, it's usually around something like $500. Setting a minimum limit on contributions and expenditures taken in is very appropriate. These organizations would never have to deal with the fact that they can never be interpreted as being a PAC then. And that's an easy way to handle that. We could even handle this in reg, frankly. I do think that the PAC registration requirements in here are extreme. No reasonably savvy organization, including the largest PACs in Kansas today, would have to register under this interpretation. It's just not possible.
That's not the question I asked. The question I asked is, you don't think that your investigations, because of the gravity, you end up chilling free speech, causing people to not do things that are perfectly legal just for fear of being investigated?
I think an organization that, in applying the regulation, was interpreted as being a political action committee and had not registered as a political action committee was asked to register and disclose according to the state of the law. That is what occurred.
You're not going to answer my question. Okay.
I think that registration requirements are not something that creates a chilling effect.
All right. Representative Howell, did you have a question?
Yes, thank you, Chair. earlier, I believe it was you that's referenced the members of the commission as being experts or something similar to that of campaign finance law. Do they take a course in Kansas campaign finance law? Do they receive a certification upon taking a course? I mean, how do they become experts after they're appointed, correct?
Yes, they are appointed and they engage, I mean, they deal with campaign finance issues every single day. They have the statutes in front of them. They have, make sure they are interpreting them all equally. Frankly, they have more exposure to campaign finance law than probably anyone else in the state outside of my staff. And maybe some people who have run for office for quite a while. We're actually pretty excited. We have at least 2 new commissioners who are both attorneys who I'm very excited to work with as well. And we're excited about some orientation on how campaign finance law and ethics laws and lobbying laws work.
Okay. Can I ask one more? And thank you. My other question is, again, not an attorney here, but when there's a search warrant, you have to have some evidence. The police officer, for example, has to have some evidence when he goes to the judge to get a search warrant. Isn't this a subpoena held to the same standard?
Police officers, frankly, have a lot more opportunities for investigation than we do. We don't have very much. We are a staff of 8.5 and only a few statutory provisions that allow us to investigate matters. We don't have an interaction with the prosecutor. We don't have those sorts of abilities, investigative options that are available to true law enforcement agencies. And so the subpoena allows us to obtain certain information to support a violation. This bill, as written, means that we would never be able to support most, especially complex violations of the Campaign Finance Act. There's just no reason to have the law.
Representative Berquist.
Thank you, Mr. Chair.
I'll come back to you, Representative Howell, if you have more questions.
Just the previous representative asked the question about what makes them more able to disseminate campaign finance law than other folks. And I believe your reference was that because they deal with it all the time. When did they start dealing with it? Did they start dealing with it in great exponent numbers as soon as they showed up on the job? Before they got the job, what was their qualification for this job?
So one of our new commissioners actually has had a good bit of exposure to campaign finance already. We have 2 commissioners, including one of our new commissioners, who at one point were either office holders or who were candidates, and this was long enough ago that no one could be concerned about. This is why right now there's a 5-year and 3-year limitations on qualification for office. So for example, if someone was a legislator in the last 3 years, they can't serve on the commission. They have to wait until that time period elapses, because we wouldn't want to have them to have to enforce the law against someone who was their chairmate on the floor, for example. That could result in some issues. But yes, they start exposure pretty quick, right off the bat. Many of them are selected because of a previous interest or experience with the matter. Some of them are, frankly, just because they're very good at statutory interpretation. But almost all of our commissioners are attorneys. I think all of our commissioners are attorneys as of today. Because we had one that wasn't, who I think was just replaced.
Thank you, Mr. Chair.
Representative Neighbor, and then I'll come back to you, Representative Howell.
Thank you, Mr. Chairman. In listening to the testimony today, and I think $22,000 is a lot of money. I will agree with that. But I also heard from the gentleman that, and this is a good quality, okay? I was brought up on principle. And so if his principle is, you don't tell me what I can and can't say, okay? That's one thing. But you also have to do that within the law of the commission, because it has guidelines. And when they took that $3,000 and then denied the ability, or denied that they weren't going to do it, they made that choice and then to go to court. So I'm sorry they're out $22,000. But it's my feeling after listening to all of this, that if they had simply gone in and said, we weren't a PAC, we understand what a PAC is, and but I just got the feeling that I'm not going to admit on my principles that you can tell me what to do and who I can support and who I can't support. And I think that's a personal issue. And it's in a silo.
Please.
Briefly. I will note that if that $2,500 was expended, or $33,000 was expended on express advocacy, this would only apply to groups like this who aren't savvy enough to know how to pass money back and forth between other groups to make them not qualify anymore. That would make 50% of their total spending in a 2-year period on express advocacy. They would have spent more than $2,500 on express advocacy. They would qualify as a PAC. This doesn't resolve the Fresh Vision problem. And that said, it would exempt all of these massive PACs who are savvy enough to know how to pass money around to hide it. So that's the problem here is I want, and I will tell you, I really do like both of those people. I'm sure they detest me. I'm sure that is absolutely true. I agree probably with almost everything that they say in the world. The issue is that in our interpretation, they were a PAC. They needed to register. But I'm not going to rerun a hearing today, even though that seems to be the focus of proponent testimony, even though that's not what 99% of this bill is about.
But, you know, the thing about the subpoenas, you know, I acknowledge that you're in the middle of investigation. You're not going to say how many subpoenas you issued, but if our friend from Sunflower State Journal is accurate, a lot of subpoenas got issued, and each one of those people had to, or each one of those agencies, each one of those PACs, each one of those organizations had to go spend money to either comply or fight the subpoenas. And so that in the middle of a campaign season, that's you know, money is speech, right? And so there is I take your point as you intended it. They made the choice to do that, but even if you're just, you know, going to comply, it's going to cost money, and you multiply that across one party or another party, that has an impact on elections.
If I could respond as well.
Yeah, please.
So there are many instances where people who receive subpoenas from the commission, they don't go get representation. They just call us and say, these are the things that I think you're looking for. Can I just give you these? We're pretty amenable to those sorts of discussions. There's no reason why anyone necessarily needs an attorney for anything. That doesn't mean that they can't go get legal counsel. It's often a good idea to get at least a consult. But that said, it's a scenario that lots of people don't take that approach. That's all I'll say about that.
So Representative Howell was next, and then I'll get to you, Representative Dodson.
Thank you, Chair. You know, one of the essential things about the country of America and being an American citizen is that we are innocent until proven guilty, and that we don't have to submit to a search warrant, or I would, to my knowledge, a subpoena without evidence, it being evidence-based. There has to be some reason for us to be forced to submit to something like that against our will. If I was to summarize the answer that you just gave me about the subpoena, it sounds to me, if I was to restate it, was that your subpoena power shouldn't have to be based off of evidence but because you don't have enough manpower and funding in order to do the investigation. Am I misunderstanding your answer?
Yes, you are. So in order to have a subpoena, we have to have reasonable suspicion of violation. We have to be able to state specific facts that support a finding of a violation and conclusions of law that also support a finding of a violation. Without all of that, if that doesn't exist, if that's not there, not only will the commission frankly not approve it, because we need 7 members physically present in the room to approve a subpoena of our 9, so it has to be pretty overwhelming. But also, there's no judge in history who would actually allow it to be enforced. We, again, cannot enforce a subpoena on our own. We do need substantial competent evidence. We need reasonable suspicion of a violation. Now, raising that standard to probable cause and requiring a complaint to be filed first, that's a level of evidence that for most campaign finance violations that are truly crucial and are huge, complex issues, it's pretty difficult to get that evidence without someone frankly, out of the goodness of their own heart, turning on the group that they worked for or something like that. It's very, very difficult to get that. But reasonable suspicion is doable. That's still evidence. We can't just go on fishing expeditions and decide that we want to subpoena things. We need actual reasonable suspicion of a violation that occurred, and this subpoena has to be specifically carved out to the information that is reasonably relevant to the violation.
Okay, so we are at 5:40, so Representative Dodson, do you still have a question? Okay, is there anybody else who's just not going to be able to sleep this weekend if they don't ask a question? Okay, thank you for your patience, Mr. Skoglund, and thank you for appearing before the committee.
Thank you, and have a safe drive back. It's looking real bad out there.
So I have no neutrals listed. Is there anybody wishing to speak as neutral on this bill? Representative Miller.
I don't know if you were about to say it, but the Attorney General submitted neutral written testimony.
Was the next thing I was going to say. I have written testimony that you guys have from the Attorney General. And I think I already asked, does anybody wish to speak as a neutral? Okay. If not, I'm going to close the hearing on House Bill 2391. If it's okay with the committee, we won't work 2167 today. I think that that's cruel and unusual punishment. What I will ask is that folks come ready to work it on Tuesday, because that's the last day we're meeting as a committee, and we got to get that, if we're going to do something with that bill, we got to do it on Tuesday. We also have a hearing on 2312. And I will be in consultation with folks here in the committee, especially my ranking minority member, to see what we do or do not want to do with 2391. Is there anything for the good of the order? Representative Berquist.
It may just be obvious, but if there's a hearing for HB 2312, is that a potential also action item?
Yeah, if I have pretty much unanimous consent from the committee, we can move to emergency action on that and try to move it out too. But I'm not going to force the issue on that. I'm only going to work it if it seems like everybody likes it and wants to move it forward.
Thanks, sir.
Okay. Anything else for the good of the order? Okay. If not, we're adjourned. Thank you.